Hi, y'all, and welcome to the live stream. Bryan Kohberger is accused of breaking into a house in the middle of the night and stabbing to death 4 college students. In their bedrooms, some or even most of them still asleep at the time. But there's a surprising reason why he may not face the death penalty. I'm going to talk about what that is. I'm going to tell you about how the death penalty works in Idaho and how it will play out in this case. We're going to compare his case to Chad and Lori Vallow Daybell. And then I'm going to give you my thoughts on whether I think the prosecution is going to ask for the death penalty in Bryan Kohberger's case. Now, remember, it's no fair saying from the title that Lee says Kohberger is not going to get the death penalty. You have to listen to the whole thing to understand my opinion. You can't just listen to 2 minutes and say, okay, yeah, I know what Lee thinks. So give me a chance. And while I'm thinking about it, what do you think about the new set, everybody? Do you like it? I hope it's a little bit better. It kind of fills out the space more, have more books. I got some feedback from Charles White saying, come on, where are all your books? And actually, I moved a lot of them from one side of the room to the other, thinking I'm going to move over there, and I just hadn't done it. So now we've got the chance. So give me your feedback on how the new set's working and what you think about it. So we've got 3 defendants we're going to talk about tonight. All 3 are accused of murder, and all 3 are accused of murder in Idaho. But potentially, they're going to be treated differently. Lori Vallow Daybell is accused of murdering her 7-year-old son and her 16-year-old daughter and conspiring to murder the wife of Chad Daybell right up until she married him 17 days later. She is not facing the death penalty. Chad Daybell, on the other hand, is accused in the same 3 murders, but he is potentially facing the death penalty. And Bryan Kohberger, accused of stabbing the 4 college students, may or may not be facing the death penalty. We don't know the answer to that yet. So one thing we do know is that we want to follow all of these cases and the most interesting cases in the U.S. So please be sure to subscribe to the channel. We're trying to reach 100,000 and we are getting so close. So thank you to everybody who's already subscribed, and please do subscribe and also hit the like button for the video. So I'm hoping by the end of the video to convey 3 things. First of all, I want you to understand who it is who's going to make the decision about whether or not Bryan Kohberger faces the death penalty. Then I want to explain kind of how it works. I guess it's really 4 things. And the surprising factor that may make it complicated for a prosecutor in the position of the prosecutor who is going against Bryan Kohberger, the thing that makes it really hard for them. What's the complicating factor? And then the 4th thing is I'm going to give you my prediction on what's going to happen. And again, got to wait till the end. No fair predicting until you've listened to the whole video. So let's talk about first, who is it who decides whether to ask for the death penalty? Now, first of all, not every state has the death penalty. Idaho does. So the death penalty is potentially on the table. It's done case by case, and it may surprise you to find out that the decision is made not by the court, but by the prosecutor. The prosecutor says, I want to pursue the death penalty, or I don't want to pursue the death penalty. That's where the very first decision is made. Now, that also means that a different prosecutor is deciding for different cases. So the prosecutor who decided for the Daybell case is not necessarily the same prosecutor who decides for the Kohberger case. It's going to be made case by case. And I want to show you the statute in Idaho so you can get a quick understanding of that. 18404A, the prosecutor has to file a written notice of intent to seek the death penalty. And you may have been hearing about this specifically in connection with the Kohberger case, because at the last hearing, what the judge said was, look, prosecution, you've got 60 days now, because the time starts running, as you can see, from the time of entry of a plea, no later than 60 days after entry of a plea. That means once the plea is made, and in this case, remember, Bryan Kohberger stood silent. That's deemed by the judge, by law, the judge says, okay, if you don't say anything at all, we're going to presume that you are pleading not guilty to the charges against you. And so that's how it came out. So they have, and the court said, now prosecution, you have 60 days to make your decision and to file a notice of intent to seek the death penalty if that is what you're going to do. And that's what came straight from this statute. Now that notice could be amended, it could be withdrawn, and depending on whether there's more information that's found one way or the other, that can be changed. But if the notice isn't filed in 60 days, the statute says it can't be done. So that's a limit on the prosecution. That's the amount of time they've got. So that's the deadline we're working with now, 60 days from when Bryan Kohberger stood silent, which was deemed to be pled not guilty in the case. And one thing I thought you'd be interested in seeing is that the court is supposed to tell jurors at the beginning of the case if the death penalty is not on the table. So if it's not on the table, they find that out. And then they, I assume, don't have to worry about it the whole rest of the time. So now I want to talk about how exactly this decision is made. And I want to say, too, thank you very much to A Numbers Girl. I really appreciate that. And I'm glad to have you on a live stream. I'm glad you liked that timeline for the Lori Daybell case. I love timelines. They help me understand and put things kind of in order and put things together. So I'm glad that you liked that too. I appreciate that feedback and also the super chat. Thank you. So I want to go through what the statute says about, and I think that's going to be big enough. Actually, here we go. I'm just going to do it. I'm going to do a share screen because I think that'll be a little bit bigger and you'll be able to see more easily. Okay. So what the statute says is the death penalty can be on the table if the person killed, intended a killing, or acted with reckless indifference to human life, irrespective of whether such person directly committed the acts that caused death. So what that means is if they were recklessly indifferent to human life, even that, and didn't directly do the thing that killed somebody, it's still an option. The death penalty is still an option. And that's why it was still an option with Lori Daybell. And let's talk about her real quickly and go ahead and set that one to the side. Lori Daybell's was supposed to be subject to the death penalty. The prosecution actually filed that notice that we talked about. They actually requested the death penalty, but the judge took it away when the prosecution, for not just the first time, but for the actually several times, failed to produce documents in time. And the judge said, okay, that's it. This is too many times, and I am now going to take the death penalty off the table as a sanction against the state. And that's why she didn't face the death penalty, whereas Chad Daybell still may. It's still on the table for Chad Daybell because he didn't demand a speedy trial. His trial is going to be in the future, so he has time to prepare. So it's still on the table for him. Okay, so the way that it will be handled in court is that and we already mentioned this, the notice has to be filed. And then the jury has to have a separate case, basically. That's a little bit of an exaggeration, but they have to have a separate proceeding where they're going to do nothing but decide about the death penalty. I'll sort of unpack what the statute says for you. So first of all, the jury has to find beyond a reasonable doubt at least one statutory aggravating circumstance. We'll talk about exactly what those are, and we'll go through. I've got a chart for you on what exactly might be decided, might be included for Bryan Kohberger and what is included for Chad Daybell. So now notice that it could be the court. If a jury is waived, the court could make the finding of the death penalty. That would be very unusual because the defendant would have to agree to that. And usually the defendant would rather have a chance with 12 different people because, as we are going to see, it has to be a unanimous finding. So the chances that 1 out of 12 would hold out on the death penalty are a lot greater than just the judge, unless the judge is a known quantity and everyone knows how the judge feels for some reason. But okay, so the jury first has to look to see whether there's a statutory aggravating circumstance. That means something that makes it really bad. And like I say, we're going to be specific. And then the jury has to look at whether there are mitigating circumstances. So aggravating is things that make it worse. Mitigating is things that make it, a little more understandable. Okay, come to think of it, I can kind of see where that might happen. Sometimes you might have something related to prior history between the two that would make it look mitigating, or there might be a past incident that happened to the person accused of murder, something like that. In this case, we don't know yet anything about the mitigating circumstances for Bryan Kohberger. And we suspect there aren't a lot for Chad Daybell, but we don't honestly know about that either because the trial hadn't started. The jury has to look at that mitigating circumstance and find that it's sufficiently compelling that the death penalty would be unjust. Not just that, he had a tough childhood. That was tough. I can see where that would make it more likely. That's not the standard. Mitigating circumstance sufficiently compelling that the death penalty would be unjust. It would literally be unjust to do that. And the jury has to find unanimously at least one aggravating circumstance, and they have to decide unanimously that the penalty of death should be imposed. That's a strong standard. And that's why typically a defendant is going to want the jury to make that choice. All of this is going to happen in a special sentencing proceeding that is just related to the death penalty. Now, the information that's going to come in is pretty broad at this point. For one thing, there's going to be a lot of information about the victim in this phase. The victim, the impact that the death of the victim had on the victim's family, the victim's uniqueness as an individual, the loss to the community because the person died. All of those things are going to come in evidence, not just what the defendant did, not just the circumstances, but things about the victim are now relevant as well. And I thought this was important. Characterizations and opinions about the crime, the defendant, and the appropriate sentence shall not be permitted as part of any victim impact information. In other words, the victim's family can't come in and say, hey, we want you to know we think you should impose the death penalty. That can't happen. They can talk about the things I've just said. They can talk about the impact on the victim, how much of a problem it created for the community, the loss to the community, to no longer have that person involved. But what they can't do is tell the jury what they want. They can't characterize, this is the most heinous crime ever. They can't say things like that. There are limits, although now in this phase, the victim is part of it. The victim is included and is now part of the sentencing. So interestingly too, the same jury is supposed to make the decision. The very same jury that just heard all the evidence and just found that the defendant was guilty of first-degree murder is now the same jury that is supposed to hear the question of whether or not the death penalty should be imposed. Now, sometimes, and the statute allows for this, it just might not be possible. It says if it's impracticable to use that exact same jury, you can convene a new jury, judge, and you can see where that might happen. If you've got a trial that runs for a substantial length of time, think Lori Vallow Daybell, and then multiply that a bit for how much longer Chad Daybell's is going to be, then because I think he'll have a more vigorous defense and because there's going to be the whole death penalty phase. So the jury's already been through that. There may be a delay while things are brought together. Victims' impact statements are made. Things are readied for that. So there may be some time where it's not immediate. There may be a gap between the trial and between the sentencing. And that could make it really tough to pull all those same jurors in again. So the court is given the opportunity to make a choice and to say, okay, I'm going to use a different jury. If it's simply not possible to use the same jury, then that's possible. Let me go back to, I want to say, Tom, you get into more trouble than anyone I know. It's terrible. Arrested for a heist. Well, I'm sorry. I just can't handle your case. But wow, that's been a lot of them. Thanks for the super chat. So the state and the defense can present evidence to inform the jury So let's think about this. This is a separate proceeding. What if there's a brand new jury that's brought in? They don't know anything about the case, right? That's part of what they'll be deciding, is that they don't know about the case. And so the state and the defense are allowed to present evidence to inform the jury of the nature and circumstances of the murder, because they need to know that in order to make their choice. But they are specifically told in advance that that defendant has already been found guilty, and that your purpose jury is limited to making findings that are relevant to sentencing. That's it. And then the parties are entitled to present all the relevant evidence in aggravation. That means the things that make it very serious and that the prosecution believes make it worthy of the death penalty, and mitigation, the things that make, in the defense mind, ought to change the jury's mind so that they don't award the death penalty or don't fine for the death penalty. So if the jury, and here's kind of the series that they can find. The jury could find we do find a statutory aggravating circumstance. We don't find a mitigating circumstance that would make the death penalty unjust, and so the person is sentenced to death. The jury could find, we do find a statutory aggravating circumstance, but we frankly do think there are mitigating circumstances, or we can't all agree, it's not unanimous, and in that case, the person gets life imprisonment without the possibility of parole. Now, it's also possible that the jury could find, we don't find a statutory aggravating circumstance, or we all agree that there is one, or we can't unanimously agree. And in that case, it's imprisonment with a fixed term of not less than 10 years. So it can be any of those sorts of things. Now, let's talk about what the aggravating factors are. And let me move down quickly. Okay. So first of all, this burden of proof is going to be that the aggravating circumstance has to be proven beyond a reasonable doubt, and whether, when you weigh it against all of those mitigating circumstances, it's still sufficiently compelling. So let's go through those, and I have a chart here for you that I will add to the screen. Okay, so the first thing that we're going to look at, and tell you what, let me, I'm going to stop the screen on that and see. I wondered if I could get a slightly different, bigger version that you can maybe see a little bit better. So let's see how we do on this. Oh yeah, there we go. Bigger and better. Okay. DA is telling me he's up past his bedtime. Well, thank you. I appreciate your staying up from Germany. I know it is a very different time there. So, and Tom, the Dan Markle case, 100% definitely going to be covering that, but there's not a lot happening right now on the Dan Markle case. So definitely, yes, I will. So, so here are the aggravating circumstances that are permitted under Idaho law. The first thing is the defendant was previously convicted of another murder. And I'm going to compare Bryan, that's the blue column, and Chad Daybell, that's the green column, so you can see what the differences are. So neither one that we know about has ever been convicted of another murder. And I think we would know about it. Not just accused of, think he committed. So it's not just a matter of finding, for example, that Bryan Kohberger committed some other murder. The person has to have been convicted of it. And that definitely hasn't happened. Next, at the time the murder was committed, the defendant also committed another murder. I would say, assuming that means that more than one person was killed at the same time, that's clearly the case if Bryan Kohberger is convicted, because Bryan Kohberger is accused of 4 murders on the same night. With Chad Daybell, you could have argued that, but the prosecution probably did not, because it wasn't really at the time. There were 3 murders, but they weren't at the same time. So the prosecution did not count that as one of the grounds where they requested the death penalty for Chad Daybell. The next aggravating circumstance is that the defendant knowingly created a great risk of death to many persons. That's clearly the case when it comes to Bryan Kohberger, because he's accused of creating a risk of death to 4 different people and actually killing them. But again, not requested under Chad Daybell, although you could argue it applied. It just didn't quite apply correctly. Next, that the murder was committed for remuneration, to get something, to get money or something in return. And as far as we know, that is not the case for Bryan Kohberger. And we do know for a fact that that is one of the things that Chad Daybell, that's one of the aggravating circumstances the prosecution is using with Chad Daybell. So E is the murder was especially heinous, atrocious, or cruel, manifesting exceptional depravity. And with Bryan Kohberger, I think the prosecution could make an argument for that. And we know for a fact that with Chad Daybell's case, the prosecution says that is one of their aggravating circumstances. F, the defendant exhibited utter disregard for human life. With Bryan Kohberger, I think the prosecution again could make that argument. We know that the prosecution is making that argument for Chad Daybell. G, murder committed in the perpetration of arson, rape, robbery, burglary, kidnapping, or mayhem, and reckless indifference to human life. It has to be committed in the perpetration of that, and there was reckless indifference to human life. With Bryan Kohberger, I would imagine that would be one of the grounds the prosecution would use if it chooses to do that. With Chad Daybell, that is not one of the factors that the prosecution has gone after. They are not saying it was included in any of that. And think about this. Remember that one of the counts against Bryan Kohberger relates to burglary, and often those seem kind of out of place. Murder, burglary. It just seems so small in comparison, but it's actually part and parcel of what the statute requires because it's part of one of the aggravating circumstances. So that's, I think, one of the reasons it would get included. And let me move up just a little bit on the chart, just a second. So H is murder, and there were so many words in this. I'm like, okay, YouTube is definitely going to flag me if I type this whole thing out. Let's just say it was murder in an attempt to perpetrate an infamous crime against nature, lewd and lascivious conduct with a minor, and I paraphrase and shorten these too, sexual abuse of a child under 16, ritualized abuse of a child, etc. And most of it related, and plus reckless indifference to human life. I don't see that with Bryan Kohberger because all the people who were involved were over the age of 16, over the age of 18. And so I don't think that would be part of what the prosecution would claim in that case. It is also not part of what what was included in Chad Daybell's. It didn't even fit, I presume, with JJ, even though he was only 7, or with Tylee, who was 16. I is the defendant by his conduct, whether such conduct was before, during, or after the commission of the murder, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. So, in short, the person is a continuing threat to society. Their tendency toward murder. That is almost certainly something that the prosecution will argue for Kohberger. And also, if you think about it, that's also one of the ways they're going to probably try to get in some of the information related to the studies he was doing. He was studying criminal justice, and he was even doing studies, writing work related to finding out how people felt about their crimes and talking to convicted prisoners about what it felt like and what they did. And I would say the prosecution is going to use that, particularly during sentencing. If they go for the death penalty, I think they'll use that. They'll say, look, that's one of the things we're entitled to prove, that he was a continuing threat, and we can do that by showing the fact that he was doing studies and furthering all of this work related to figuring out how to commit crimes. That was one of the things he was doing. So I think they will include that, and the evidence will be one of the reasons they include it. Then also, it is one of the grounds that was used in Chad Daybell's case. The next is murder of a peace officer, officer of the court, etc. As far as we know, there was nothing related to that. And I think we would know for either Bryan Kohberger, and it wasn't true for Chad Daybell, or murder of a witness or potential witness in a criminal or civil legal proceeding because of that proceeding. So again, that's not really what we're talking about here. So that would not be included. So now I want to talk a little bit about why there's a surprising reason why the prosecutor might not ask for the death penalty in a case like this. Again, you have to listen all the way through. I'm just explaining why they might not, and then I'm going to give my opinion about whether I think that they actually will ask for the death penalty in this case. You might think this is super easy, right? I mean, look at what's happened here. There is the death penalty in this state. Why would they not ask for it? It's pretty complicated, and I want to show you why. I want to show you some of the studies and things that explain why it's difficult sometimes for the prosecutor to make this decision. First of all, and you can see this from the map, I guess you'd call it, put out by the Department of Justice. The only states that have had this is done for year-end 2020, just that 1 year. It was the most recent I found that was available. And in that year, only 4 states executed somebody. Now, all those other light blue states had the death penalty, but no one was executed. So it's not all that common. And as you can see from that map, and the reasons for that are both time and money. Now, let's take a look at some information that is straight from the Death Penalty Information Center, talking about the number of death sentences from 1973 to 2022. And you can see the trend downward, so that the total number of death sentences by 2022 was, it looks like, roughly about 20. And that's death sentences across the entire nation. That's not just one state or just Idaho. This is across the entire nation. In other words, it's very rare. It's very rare that a death sentence is imposed. And then there's the question, not just of the death sentence, which is where someone supposedly is to be killed by the state. There's also the number of people executed. That is also very small relative to the number of cases in the United States. So here's a graph showing the number of people executed in the United States from 1930 through 2020. And you can see that in 2020, it was probably 20 people who were executed. So you've got a combination of not very many death penalty convictions and not very many death penalty actually being imposed. Both of those are relatively uncommon, in other words. Here's another graph showing you executions from 77 to 2022, and you can see that it has been falling significantly since about the year 1999, that the number has fallen and it looks like 19 in 2022. Idaho, for example, you can see from this graph, this one coming again from almost all of these are from the Death Penalty Information Center. And to be clear, the Death Penalty Information Center is opposed to the death penalty. Unashamedly, unabashedly, that is their goal. So, but most of these statistics they pull from DOJ. They just make them graphically something that you can kind of understand and see a little more easily. So that's why I'm using them. So you can see that Idaho had a death penalty, but Idaho has not actually executed anyone for 10 years. So the sort of, I don't know what color you'd call it, but mauve, I guess, the mauve states haven't executed anybody in 10 years, even though they have the death penalty. According to DOJ, and it's a little hard to see this, so I'm going to switch straight over to, and that's the difference that I'm talking about. This is the DOJ version, and this is the death penalty information version of the average time between sentencing and execution. And this is super important because the length of time it takes between the time that someone is sentenced to death and the time that they actually are executed, all of that is a substantial amount of time that the state has to house them, has to keep them on death row, has to pursue appeals. It's very expensive, and it has taken longer and longer and longer through the years. Currently, 227 months is the average amount of time that it takes from the time that someone is sentenced until they're executed. And when you think about it, sentenced is fairly far along, because the sentence part is after the person has already, it's often years past when they committed the murders, and then there's a trial, and then there's a sentencing hearing, and they're finally sentenced. All of that takes years often. And then it's another almost 18.9 years past that on average until the execution takes place. All of that lengthening of time has made it more and more likely that prosecutors make a choice. Okay, we're not going to do that here. There have been studies and questions about, okay, how much more does it cost if you impose the death penalty than if you don't? And there's no clear answer on that. Tennessee looked, for example, at just the cost of the trial itself and said, well, a death penalty trial costs 48% more. But then you've got a bunch of competing factors, like the fact that if someone is executed, the state no longer has to pay any money to house or feed them. But on the other hand, if there's a 20-year-long set of multiple appeals, that takes so long. The trials obviously cost more because there's a death penalty qualified lawyer who has to be hired. We've heard that as Chad Daybell, Bryan Kohberger's team has added death penalty qualified lawyers to the team so that they had people to support them in that area. There's an extra phase of trial. There are multiple layers of appeals, not just one. It doesn't just go through the state. It also goes through the federal, and usually that happens more than once. When I clerked for the 11th Circuit when I was just out of law school, and we did for the rest of the country, a large number of death penalty appeals. I was not the death penalty law clerk in our office, but we did a large number. And I was just astonished to see how long it took, because I had this sort of naive view that if the death penalty was imposed, then, and I mean, since the sentence was made that the person would be executed, that it happened within a week or two or something quick. And I found not the case at all. Here, there is an extra layer when it comes to Bryan Kohberger, because there's a very unusual situation where some family members of victims have said, we really want there to be the death penalty in this case. Kaylee Gonsalves' parents have said yes. On the other hand, members of Xana Kernodle's family have said, we don't think the death penalty should be imposed. So that's more that the prosecutor has to take into account and deal with as part of making this choice. So at long last, and here's where it is for real. This is my view on whether they're going to ask for the death penalty for Bryan Kohberger. And let me say thank you to Pretty Pearls for the super sticker. I appreciate that. As sensational as this case has been, I do think that they will ask for the death penalty. I don't really think they'll have a lot of choice in that. Whether the jury concludes the death penalty is warranted is a completely different matter and depends on how much evidence the state has, both to convict Bryan Kohberger and then of those aggravating circumstances. So far, they have been very tight with the evidence. And so, but there are hints. They've given hints that they believe the evidence is very, very strong. So I believe it's very likely that the prosecution is going to ask for that. The defense thinks that also. How do we know? Because they've asked for the death penalty qualified co-counsel. So they think also that there is going to be a request for the death penalty in that case. Bryan Kohberger's decision to stand silent may have been part of a plea deal where his side is trying to plead guilty. I'm just inventing this. Don't take this as word. I have no inside information, but perhaps they're trying to strike a deal where the death penalty would be taken off the table if he will just plead guilty to the murders. That may be part of them not wanting to antagonize the families by having him stand up and say, I wasn't guilty. They might think that would make, both in the public and with the families, that would really make a poor impression and make people angry. So now, how likely is it he's going to get the death penalty? Well, you saw from those graphs I showed you, it is not done often. There are currently 8 people on the death row in Idaho. This would be 2 additional people. This would be both Bryan Kohberger and Chad Daybell being added, swelling the numbers by 25%. The last person executed in Idaho, 2 people, November 2011 and June 2012. Those were the last 2. There have been only 29 executions in the United States since 1984. So it's very, very rare. We can't know yet how likely he is to get it, I think, without a lot more information. Of course, first we have to know whether the prosecution is going to ask for it, but we also have to know what the evidence is. And we need to know a lot of things that haven't happened at trial yet, like, are there good grounds for appeal? Is what happens with the jury? We'll need to know all of that. And let's talk next about how it will happen. And let me say thank you to Justice for the super chat. Thank you very much. One of the reasons that the death penalty has been used less and less is the difficulty finding lethal injection drugs and purchasing lethal injection drugs. The Idaho State Legislature, for example, just this year brought back the firing squad as an alternative. If the drugs cannot be obtained to use for executions, then there is permission from the state legislature now to allow there to be a firing squad. That's an alternative now. 5 states have the firing squad: Mississippi, Oklahoma, Utah, South Carolina, and now Idaho. Now, there have been only 3 firing squad executions since 1976. So all of those things are part of what will be decided. There is one of the reasons they passed that legislation in Idaho was there was somebody who was coming up for execution and they couldn't get the drugs to carry through. So they were trying to come up with an alternative. So that is an alternative that could be in play for either Kohberger or Chad Daybell. So let's talk about what we're going to be doing next week. We're going to be looking, I'm considering these 4 topics. We can do more than one. So kind of let me know your thoughts, if you would. First of all, Jeffrey Epstein. My primary reluctance on this one is it requires discussing a lot of unpleasant topics that YouTube doesn't like. For example, something that rhymes with pesticide, sort of. But let me know how interested you are, because there's a lot of new information now about whether or not he in fact killed himself. Surely they'll let me say that, in prison. And so, if you're interested in that, let me know. An update on Corey Richens is definitely in order, I think. You may remember that she was accused of poisoning her husband with a massive drug overdose and then writing a book to comfort her children and help them deal with the loss of their parent. That's the accusation against her. There's new information now about insurance policies that she allegedly purchased for her husband in case of his death. And of course, the money she stood to gain if he died. So those are some new allegations. I'm also interested in doing an update on Lori Shaver. You may remember the video I did on that. She was accused of murdering her husband and burying him in the backyard, and then pretending to be her husband for 3 years to hide the fact that he was dead. Then building a fire pit over his body, and she now claims her 7-year-old committed the murder. So those allegations were certainly of interest. I think everyone was definitely interested in that case. And then also an update on Lori Vallow Daybell. You may have heard that her team moved for a new trial, and their argument was that a juror said something in a post-trial interview that revealed he had information he hadn't told the team about. So did the juror undermine the verdict? Is something going to change in that? If that interests you, let me know. And of course, possible update on Brad Pitt and Angelina Jolie in the wine wars, as I call it. She sold her half of the family winery to a Russian oligarch, and he's mad about it, and it's drama on both sides. So obviously we'll do any updates on Alec Murdaugh too if that comes in. So be sure to vote in the comments and be sure to like and subscribe because you do not want to miss all the legal news that we'll be covering next week.